There you go. Thank you. Pay him that? Yeah.
Right, this is case number 15-2-3-2-3-3. This is American Road Service Company versus Kathy Reyes Velez. The matter is before the court on an adjourned pre-trial.
Thank you.
Appearance at this time for the plaintiff, please.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff P number 74809.
Right, thank you, counsel. Good morning to you. Court defendant in this matter.
Good morning. I'm Attorney Mark Linton on behalf of the defendant.
Your P number for the record, sir.
P66503.
All right, thank you. I believe I got some information that this might be resolved as there was some discussion of that at the previous hearing. Go right ahead, Ms. Williams.
That is correct, Your Honor. I received permission actually this morning from my client giving me permission to dismiss this action against Ms. Reyes Velez, the defendant in this case. Am I pronouncing her name correctly, Mr. Linton?
It's actually now Katie Davis Head. She's changed it, but
I apologize. Against the defendant in this action, Katie.
All right, the plot thickens. All right, Mr. Linton, I suppose that there is no objection to this matter being dismissed as was anticipated along the way. Is that correct, sir?
yep, that's correct, Your Honor.
All right, the court will enter an order of dismissal regarding this matter. I could sign off on the standard dismissal. That you want to present something, Madam Counsel?
The standard dismissal is fine with plaintiff unless Mr. Linton wants something different.
No, that's fine. Thank you.
All right, thank you. Good day to the two of you. You'll get a copy of the order of dismissal in the mail. Good day to you.
Thank you, Your Honor. Take
Thank
care.
you. Have a good day.
Thank you, Mr. Linton.
The court now calls case number 21-149963. This is Michigan First Credit Union versus Nicole Willis. Matters set before the court for a looks like a pretrial hearing. Your appearance for the plaintiff first, Michigan First, please.
Good morning, Your Honor. Wes O'Neill on behalf of Michigan First, P number 80307.
All right, thank you, Mr. Neal. Good morning to you, sir. I'm looking for Nicole Willis at this time. Ms. Willis, if you're on the Zoom, please say something at this time.
Good morning.
Good morning to you, Ms. Willis. All right, counsel, update me. I know I adjourned this for a previous date. I granted an order setting aside the dismissal and reinstating the case on a previous date. Counsel.
Your Honor, so we had submitted a motion. Well, previously, the parties have agreed to a consent judgment. We submitted multiple copies. The defendant had not heard anything because no action was taken on the file. The court had dismissed the matter. Advising the court of the situation, the case was reinstated, and we have refiled or renoticed our motion for summary disposition, which should be up for today's date.
All right. I do see the motion in the. I do see it in the file. All right, Ms. Willis, you received a copy of the plaintiff's motion for summary disposition regarding this matter. Is that correct, ma'am?
No, I can't really say. I have so many documents. I have closure. I think letters for closure. I don't know about no other disposition paperwork.
All right. So it would have been sent to the address on Field Street. You would have received the order dismissing the case, but as you were aware from this hearing, the case was reinstated. And prior to the case being dismissed, there was in fact a motion for summary disposition in this matter. And in that motion, the plaintiff is taking the position that you have not raised a valid defense to this retail installment contract. So tell me, do you have anything that you wish to tell me by way of offering a defense to this, that something that demonstrates that you paid it or that you never entered into the agreement? Talk to me and tell me what you.
No,
what you
I
wish to-
remember, you know what, Your Honor, I got so much going on. I remember we entered agreement. I think when was our last court date? Like last year or something? I'm not even sure when the court date was. We entered into agreement to make a payment for, I think it was $200 a month. I responded to the attorney, never got a response about all these extra fees and things like that, because I thought last time we came to court, it was stated, I think like 5,800 and some change, whatever the change was. All the rest of these fees, like I thought they were taken off. So that was where I didn't agree with none of that at all.
All right, gotcha. All right. So how much do you believe that you owe, ma'am?
I thought that it was just 5,800. Where'd it go? Oh,
So
I thought it was like,
yeah, what happens is that.
yes, Your Honor.
When there's an agreement entered into or a judgment is entered, there are some fees that apply to that. And one of those fees is the filing fees for filing the case. And then there is a statutory attorney fee that applies as well. Let me ask Mr. Neal, what are you looking for by way of the total judgment amount that you're requesting, Mr. Neal?
Your Honor, the initial damages is $5,847.34. Court costs plus attorney's fees is $244.04. Interest accrued thus far is $769.28 for a total amount due of $6,860.66.
How is it that you're alleging that amount of interest, counsel? On what basis?
That would be based on the principal contract, Your Honor, which does provide for interest.
So this was an installment contract regarding looks like the purchase of a motor vehicle, and under that contract, you're saying that there is a provision that allows for the accrual of interest. Is that correct, sir?
That is correct, Your Honor.
That therein lies the situation, Ms. Willis, is that because of the nature of this agreement, because it was a retail installment contract, it allows for the accrual of interest, and that would be placed in the judgment on entry. So that's why you're getting that additional number, is because of the contract that was signed that allows for interest to accrue. That's the situation.
Okay. Now, Your Honor, I'm looking at this form and it says $149 cost and $75 attorney fee. He just said it was $250. Where did that payment come from?
Counsel, you said that it was $240 for filing fees and costs. The defendant is referencing something in the nature of about, I guess it would amount to $225. Is that a service fee or something involved in it? What's going on?
I believe there's probably additional charges associated with moving this action forward since the time that any proposed consent judgments were sent.
All right,
Okay, I'm confused because on this paperwork, they documented $149.04 for cost. How does it jumps up again? And then it's $75 for attorney fees. How do you just keep making, like you just coming up with a figure on your own? If you document something and send me something, that's actually what I'm going by.
Yeah, but what are you saying? You're saying that the $149 in cost and plus $75, is that what you're saying? You're saying, ma'am?
That's this document I'm looking at.
Yeah, if you're looking at that document, those two numbers, when you add them up, they come to like $225. So there would be a difference. There would be a difference of about $40. I'll reduce that amount to $225. I'll go with your number on that. It does appear after listening to this matter on both sides that there's no genuine material issue of dispute as to the underlying claim. That is whether or not there is whether or not there was a contractual agreement, and number two, whether or not there was a default on that agreement. The court then finds that other than other than issues of cost or the issue of damages, there is no genuine material issue of fact. Accordingly, the motion for summary disposition will be granted under those circumstances. Having listened to the allocution with regard to costs and fees in this matter, the court will at the amount paid plus the $225 and the accrued interest. The combination of those three amounts will constitute the judgment in this matter. Defendant has indicated that previously there was a offer to for payments to be made at $200 per month. Are you still prepared to enter into that type of arrangement, ma'am?
Yes, but I have another question, Your Honor. Okay, on this paper, it says the judgment, the interest is $494.10, and it's from March the 1st, 2021 to January the 20th, 2022. Okay,
Yep.
I heard him say, give me another amount. I heard him give another amount, and it was at the 9.49%.
Yeah, that's because we're now at August, or excuse me, we're now at the near the end of July. So that updated number that you had was in January. You have interest that accrues from January up to the present time. That's why you have the 700 as opposed to the number that you had in January. That's
From January to July.
Yes, ma'am.
Okay.
All right, so I'll enter the judgment. I'll allow for the $200 payment. When I will commence that payment in the month of August. I set the payment due date on Fridays, ma'am. Which Friday would you like to be your first payment of $200? The first, second, third, or fourth Friday?
Can you make it on the third Friday?
Third Friday. All right. So we'll put it.
Yes.
August the 19th will be the first payment, $200 that would be due in regard to this matter. And Mr. Wesley is going to submit a judgment based upon the summary disposition order, and I'm going to sign that order. It's going to have in it the $200 payment. As long as you make that payment on time, then no action can be taken as it relates to garnishing wages or anything like that. But if you miss the payments, then they can have that part set aside, and then they can go after your wages to try and collect on the judgment. I'm going to put you in a breakout room with Mr. Neal, just for purposes of identifying exactly where you need to make your payments. And so you get a notification from me right now, ma'am, and Mr. Neal is getting that as well.
Okay.
And I wish it will be well. Good day to you now.
Thank you, Your Honor.
Good day to you.
All right, the court now calls case number 2159-430. This is the case of Modern Financial Services Corporation versus Shannon Sales. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect regarding this matter that a judgment was entered. Just one moment. A judgment was entered on the 20th, strike that, the 16th of November, 2020 for $11,912.53. The current effort is an effort to collect on that judgment. Your appearance for Modern Financial, please. Modern Financial, anyone present in that regard? All right. Do I have Alexander Hart on this Zoom?
Yeah, what's the? I don't think that's it.
Well, it has Hart. Case number is 2159-430. Well, yeah, that's a Coleman. Do I have Alexander Hart on this Zoom?
I didn't see anything in here for it.
All right. If you're on the Zoom, please say something at this time. That's one of the code things. So it's so you that case when you have sales?
Yes, it says Alexander Hart and sales.
Yeah.
No
So,
court
Mr.
date said, I don't know.
So it appears that Mr. Hart has not appeared for the hearing regarding this matter. He sets forth in the filing of the objections to the writ of garnishment, does not check any of the boxes as to why he's objecting. And then defendant has not appeared. For that reason, the objections to the garnishment will be deemed as invalid. And any funds that are withheld would be released to the plaintiff at this time. Defendant has failed to appear, and the objections to garnishment are deemed invalid. So the court now calls case number 10-110-313. This is Hirschberg Acceptance versus Shanita Yancey. The matter is before the court on the filing of objections to a writ of garnishment. This is based upon a judgment previously entered. Let me put the entry date here. A judgment was entered on the initially on the 21st of July 2010. That judgment was reinstated on July 20th, 2020. The judgment amount on entry was $1,200.43. All right. For Hirschberg acceptance, your appearance, please.
Good morning, Your Honor. Gary Feynman appearing on behalf of Hirschberg Acceptance, P41655.
All right. Do I have Shanita Yancey on this zone?
Yes, sir.
All right. Thank you, Ms. Yancey. I received your objections to the writ of garnishment. You indicate by the checking of a box, you said the plaintiff, the writ was not properly issued or otherwise is invalid. You said I was not served a copy. There are no files. It's over 10 years old, no receipt, proof of service. All right, ma'am. None of those seem to be objections that would stop the judgment that has been entered and then renewed after 10 years. The fact that 10 years have passed is of no consequence if the judgment has been renewed, and it was renewed previously. Now,
I saw the original receipt that paper served to me. I have no knowledge to what I am paying for. And I am objecting to everything because I don't agree with them even garnishing me for something I have no knowledge of what they're garnishing me for. And I've never been served any papers for what they're stating that I owe them for as well. So I would like to see an original receipt. I would like to know why they are garnishing me and what they garnishing me for and what they took my money for.
all right. You would have to file a different motion to deal with that. This is post judgment, but to give you some information, I have on the court's register of action that in 2010, that is June 14th of 2010, that you were personally served with a summons and complaint that you did not respond to the summons and complaint, and therefore a default judgment was entered on the 21st of July of 2010.
Okay.
No, I'm still talking. Subsequent to that time, there were writs of garnishments issued against you back in 2011, 2012, 2018, 2019, et cetera, over the years. And then there was a motion to renew the judgment in July of 2020, and that judgment was in fact renewed. And then there have been subsequent efforts to garnish wages, et cetera, during subsequent to that time in 1920. So this has been going on since 2010, and there is a proof of service in the file that demonstrates that you were served back in 2010. You never filed a motion back then to set aside the default, but that I can't even take any of that up today. The fact is that this judgment has been in place, and the law does not allow me to consider it in a post-judgment situation. This is a post-judgment writ of garnishment. The kinds of things that give rise to an objection to a writ of garnishment is that I already paid it. I filed bankruptcy. I have an installment payment, things along that line. Not that that I don't believe that the judgment should have been entered against me. You have to file a different type of motion to address that. That's called a pre-judgment issue. This is a post-judgment issue. Let me hear from Hirschberg on this.
Yes, Your Honor. For all the reasons you set forth, this objection is not valid. I would also note for the record, apparently there's been several objections filed, and Your Honor entered an order on June 29th saying defendant has filed several objections, but has consistently failed to appear. If she files objections in the future, she will be required to pay costs of $250. And it appears that that was entered on June 29th, 2022. So for all the reasons that Your Honor has set forth, I request that this objection be denied and that she be assessed costs of $250.
Now, why didn't you show up on the other dates that you filed motions? Because over and over I called cases, filed an objection, you never showed up.
The first time when I showed up, you said I was a few minutes late and I had to re-sign. I started a new job where I was unable to make those appearances because I was at work and I wasn't able to leave my job. But the thing that I would like to say is in 2010, I suffered a nervous breakdown. So for them to say that they served me some papers that I have not received, and whatever I need to do to contest that, I will do so. And because I know I will have to just go ahead and get an attorney as opposed to paying for something. I've been on Social Security. So, and I had my filed papers where my identity was and someone had I had to get all my ID and everything over. So again, for them to say that they served me and I have not been serviced, I have not been served no papers from 2010. And that's why when I got my job and all of a sudden
Let me stop, ma'am. Let me stop. You're gonna have to bring a different type of motion to even address any of that. And
okay.
One of the most interesting challenges that you're going to have there is that you are 12 years past the entry of the judgment, and you've never found any objections for which you've appeared over the years, saying any of the things that you're telling me now. But you still can file the proper motion and present it to the court nonetheless. The question
Yes, sir.
is I issued an order saying that because you filed so many motions and did not show up for the hearing, that if you filed another motion, that it would cost you $250 to file an additional motion. And then you filed another motion. I mean, the concern is that you can't keep filing motions and don't come to court, because what happens is that if you file a motion, that triggers the other side to pay their lawyer to be here for the hearing. And then you don't show up, and they still got to pay that lawyer to show up, and you didn't show up on several occasions. That's the issue right now. The objections at this time will be denied. I don't see any basis for the objections. Again, this is post-judgment. The law does not allow you to raise the kind of issues that you're raising in a post-judgment garnishment action. So I'll find the objections invalid. Any funds withheld will be released to the plaintiff. You do have the right, if you wish, to seek to make partial payments while you proceed to attack the underlying judgment. But at this time, the objections will be denied because there's no basis for them. Moreover, Well, I'm taking into consideration, ma'am, I do remember you coming in one time and telling me that your job did not allow you to chime in, but then it was a couple of times after that where the hearing was set and there was simply no call to the court or anything. You simply did not show up for those hearings. All right, so I will reduce the cost. I will assess costs at $150 in this matter for the reasons set forth on this record. So ordered.
Oh, yeah.
I wish you well, ma'am, and good day to you. You were
Yeah.
saying something.
Yes.
Go ahead, ma'am.
Yes, I was asking you, can you tell me what papers I need to file so that I can pursue this situation? Because that's the problem. Every time I've been coming down there.
You asked me a question, and then you're talking again. The likelihood, here's what I want to be real frank with you. The likelihood of you being able to get that judgment set aside is like almost zero. There's nothing there that's going to give you the opportunity to do that. You can talk with a lawyer and they can tell you maybe they'll tell you something different. But I don't know of anything that you can do that's going to work to get that judgment set aside. But you need to talk to a lawyer. I can't represent you as a lawyer because I'm a judge. I can only tell you that you could file a motion. You want to talk to a lawyer, they'll tell you what kind of motion to file. But
Okay.
I want to make sure that you understand that the likelihood of you getting any relief from that is almost zero. You don't have anything to work with. But if you want to try it, you can certainly try it. That's up to you.
I
Okay?
definitely will.
Wish you well, ma'am. Good day.
So the money that I gave you, the $250, are they gonna give me my bond money back?
I have no idea what you're talking about.
I paid $250, $250 for the court hearing. And I believe you just said that you were charging me $150 for filing the.
So the other $100 will be applied towards the judgment. So I reduced the cost. The additional $100 will be applied towards monies that you owe on the judgment.
The judgment has already been paid in full.
All right, let me check with the other side. If that's the case, you would get the $100 back. Counsel, is that correct?
Not to my knowledge, Your Honor.
It has been.
All right, so counsel, what do you show as a balance, sir?
I don't have that information in front of me. I was just asked to cover this hearing, so I don't have that information. I'm sorry.
So then if the judgment has been paid in full already, then the $100 of the $250 will need to be refunded to the defendant in this matter.
It has. It's been taken out of my.
Ma'am, I didn't ask you anything, ma'am. I didn't ask you anything. Did you hear my ruling? My ruling is that if you pay the judgment, then the balance of $100 will have to be refunded to you. Hopefully you understand that. All right, counsel, you understand that as well to communicate that to your client?
Yes, Your Honor.
All right, thank you. Good day to you. Good day to both.
Thank you, Your Honor.
Good day.
Good day.
Asshole.
All right, this is case number. Yeah. That's what I was- So it should be. That's the.
Yeah.
All right, the court now calls case number 10-111, strike that 10-114-754. This is West Point versus Maggie, strike that Mary McGee. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 11th of September 2020. That was a renewal judgment in the amount of $1,498. The judgment was previously entered or the initial judgment was entered at a much earlier time. And it appears that the objection is addressing the plaintiff's effort to collect on that outstanding judgment. Looks like this is a garnishment in relationship to Kroger's. All right, West Point property, if you're on the Zoom, say something at this time. West Point.
Good morning, Your Honor. Michael Gothals, P number 48992, appearing on behalf of the plaintiff, Westport Property Management Limited.
Thank you, counsel, and good morning to you. I'm looking now for Miss Mary McGee. If you're on the Zoom, please say something at this time.
My name is Mary McGee, Your
All
Honor.
right, good morning to you, Miss McGee. This is your objection to writ of garnishment. I've looked over the form, and you didn't check any of the boxes. You did check number 2. You said, I object to the written statement I received from the creditor because the balance of the judgment is wrong. So why are you objecting? They're seeking our money, and what's the basis of your objection now?
My objection is I left the property in 2007 and I got sick on the property, and my hospital bill was $100,000 because the man had dug out 2 apartments at the bottom of the unit and asbestos was coming up, and they had to rush me to the Ford Hospital, and I stayed in there for about 2 months on a respiratory.
So why did you raise that back in 2010? That's when this judgment was entered. It was entered initially in 2010, and you've been garnished multiple times since then. Go ahead, man.
I didn't know because I figured the little rent I owed them, I didn't think it'd take it to this level. And I just started at Kroger's and I got injured there. But I'm gonna have to end up suing them because I look at it, I got sick on your property because they was negligent, because they did that contract with the city of Detroit, and the man just greedy, that's all. And the little rent I owed him, I only owed him for a month.
Well, ma'am, I can't even take any of that into consideration.
I know you can't.
It's been 12 years, ma'am. You would have had to raise that.
Yeah, but they ain't got in contact with me. Yeah, it's been 12 years. I shouldn't even see. I don't even see why I should have to pay that little rent.
Well,
and they done took over. They done already took out of my check. They took $900. Now they saying I owe them $1,400.
All right, counsel.
Well, Your Honor, Mr. McGee's written objections, which I did file a response to. I don't know if that's in the court file. She simply objects to the written statement received from the creditor because the balance of the judgment is wrong. I did mail her a
You did.
Excuse me, ma'am. Go ahead.
I'm sorry.
I did mail her a written statement on June 18th, as she indicates in her objections, and as provided under the Michigan wage garnishment statute. And that letter, which I attached to my response, did give a correct statement of the judgment balance as of that date. It gives the judgment balance, and then it gives a breakdown, starting with the balance listed in the writ, gives the amount of the statutory interest that accrued since then, and the amount of payments that have been received, and cites the most recent payment by check number and amount.
Let me ask you this. That did not populate to the court's file yet. And I heard Ms. McGee say that she did in fact receive it. So how much is owed? What's the balance on this judgment at this time?
As of today, as opposed to June 18th, the balance is $821.27 due to payments that have been received since the date of the letter.
All right, and was one of those payments a payment of somewhere in the nature of $900 or so?
Let me see, Your Honor. The letter was on June 18th. I've received 3 payments since then. $123.62, $6.65, and $112.38. We have the check stubs for each of
Gotcha.
them.
All right, so that's where things are at this point. And the big issue that you run into now, of course, Ms. McGee is the accrual of interest on the judgment that's been around for some 12 years.
Okay.
So it looks like the balance is 821. Looks like the garnishment, well, the garnishment is ongoing. So, you know, I don't see a valid objection regarding this matter. And so I will find the objections invalid. Any funds withheld will be released to the plaintiff. And you could request a partial payment type of arrangement where you could pay it voluntarily over time, or the garnishment continues until the balance of $821.27 is paid.
Okay, it's no problem. I'll just make partial payments and I'll take care of my other half on my other side. Thank you, Judge.
All right. I wish you well, ma'am.
Thank you. And Judge, I
Yes,
have
ma'am.
one thing. I have one thing to ask you.
Yes,
I growed up with you, I think,
Really?
and I voted for you. And I used to live on St. Clair and Berners.
Oh, not for real. St. Clair, where? I don't say. We were the corner house there, right?
We
You
was
were
on we was on the corner house too. I'm Holmes. I'm Mary Holmes, Cassandra Holmes.
Oh, yeah, yes, absolutely. I know who you are.
But it's good seeing you.
It's good seeing you as well. You continue to be well. Get this over with, you know?
Yeah, I am. My husband told me just to get it over with, you know. So, okay.
Right.
Thank you.
Best you. Give my regards to everybody, okay?
I will.
All right.
Thank you.
All right. See you.
Thank you, Your Honor.
Thank you. Thank you. Good deal. Why do I have, Mr. Stedman, you were back on a matter that you went out into the breakout room on. Is that correct, sir?
No, Your Honor. I'm here on the last 3 is 431. It was listed as a motion, some type of motion against my client, Michigan Auto Recovery Service, and my client, Gregory Arrigo, the president of the company, is on the iPad as well, Your Honor.
Give me that full case number, if you will, sir.
Yes, sir. It's 21-240-431 GC.
Just give me a register. All right, this is, we're working. Case number 21-240-431. This is Monty Howard versus Michigan Auto Recovery. The matter is before the court regarding a motion to set aside a dismissal. I received a motion sometime after about the 23rd of May 2022, and the court scheduled a hearing on the motion to set aside the dismissal and set today's date as the hearing in this regard. All right, any appearance for Monty Howard? Monty Howard on the Zoom, or anybody appearing for Monty Howard? Please say something if you're on the Zoom at this time. For defendant Michigan Auto Recovery, your appearance at this time, please.
Good morning, Your Honor. Thomas Stidham, P 56504, on behalf of the defendant, as well as I just want to note for the record, Your Honor, on the iPad, Mr. Gregory Arrigo, who is president of the defendant company, is here with me as well.
All right, thank you, counsel. Did you receive a copy of the motion to dismiss or to set aside the dismissal, sir?
I did not, Your Honor. I only by accident stumbled upon this hearing date.
All right, we would have sent you a notice of the hearing date. Likely would have been sent to you and to recovery at in Southfield. But the critical issue here is that Molly Howard, who filed that motion, has not appeared to seek reinstatement. And no other indication of that person requesting an adjournment or anything is indicated before me. And for that reason, the motion to set aside the dismissal will be denied at this time.
Thank you, Your Honor. I did want to ask the court, would the court condition the order pursuant to MCR 2401 G1 on the payment by the plaintiff of our reasonable expenses? We've been here twice. We've spent almost about just over an hour and 3/4 on these two appearances. And obviously, as the court stated earlier in another case, you know, the defendant is still getting billed. So I would ask that the court impose an order that in the event the plaintiff files another motion, that he be required to pay defendant's reasonable expenses in the amount of $500.
I won't allow that in the order, but if another motion is filed, the defendant did not appear on this motion, and if the court allows for another hearing, which is it's a bit of a mountain to climb. This is the plaintiff. This is the plaintiff's complaint. The plaintiff didn't appear for this matter, and it was dismissed. Then the plaintiff filed a motion to reinstate after dismissal, and the court gave the opportunity of a hearing. The plaintiff didn't appear. If the plaintiff files another motion and does not appear, or appears without some extraordinary explanation as to why the defendant has the plaintiff has failed to appear on previous occasions, the court would be inclined to assess costs. But I'm not putting that in the written order. That's just the way that this court does business. The whole reason that this matter is before the court is because the plaintiff filed the suit. Plaintiff moved to reinstate. And if the plaintiff comes back, then I'm sure that Mr. Statement will raise these issues as he has done here, and they will not go unnoticed. So the simple thing now is that the motion to set aside a dismissal is denied.
Thank you, Your Honor. Will the court issue the order?
Sure. I'll make sure there's an order in that. All right.
Thank you, Judge. Have a great day.
All right, likewise.
Mr. Ego, you can sign off now. Thank you.
Mr. Ashton, you there? Are you waiting on something here, sir?
Yes.
Thank you, Your Honor. I am. I received a notice of a motion on case number 211666092 and was uncertain if it was proceeding, so just wanted to be in attendance.
Yes, sir. Yes, sir. And I have a notation. I do have that on the docket. I think I sent this as a review date, and it indicates to me that the matter has been resolved. Is that correct, sir?
It has been. We're just waiting for the check to be received by plaintiff.
All right, got it. All right. So the record reflects simply in this matter that the matter has been resolved. The court did conduct the review today on this matter, and that review satisfies the court that that this case is either dismissed or pending dismissal based upon the settlement. Thank you,
Very
Mr.
good,
Massey.
thank you. Your Honor, I know that the court did previously enter a initial order for dismissal conditioned upon city council's approval. Just for our own purposes, would we be able to enter an actual order for dismissal at this time that would be received by the court?
Yes, but if you look at the nature of the order that I sent, and I don't know how this is still on the docket after I sent the order, actually. If you look at the order that I sent, it says that upon approval and the issuance of the payment, that order becomes a dismissal with prejudice. So that order should satisfy those conditions. If you wanted to do something additional, I certainly will receive any order regarding dismissal of that.
Understood. I'll discuss it with the client. I know sometimes they like to have the more standard order for dismissal, but I'll see if they'll be satisfied.
Not a problem. Not a problem.
Very good. Thank you.
Good seeing you as always.
Thank you. You too.